The COVID-19 pandemic had a devastating impact on many businesses that relied on commercial lease agreements. Due to lockdowns, social distancing measures, and reduced consumer demand, many tenants struggled to pay their rent and keep their businesses afloat. Some tenants asked their landlords for a temporary pause on rent payments, hoping to survive the crisis and resume their normal operations once the situation improved. However, most commercial lease agreements did not have any provisions that allowed for such a pause in case of an unforeseen event like a pandemic. In fact, most commercial lease agreements did not even have a force majeure clause, which is a clause that excuses a party from performing its obligations under the contract if an event beyond its reasonable control makes it impossible or impractical to do so. Force majeure clauses are common in other types of contracts, but not in commercial lease agreements. Even if a commercial lease agreement had a force majeure clause, it might not have covered a pandemic as a qualifying event, unless it was specifically mentioned in the contract. Therefore, most tenants had no legal basis to stop paying rent or terminate their lease agreements due to COVID. They had to rely on the goodwill and discretion of their landlords, who might or might not have been willing to negotiate a rent relief or deferment. Some landlords were sympathetic and flexible, while others were strict and uncompromising. Some landlords and tenants were able to reach an agreement that benefited both parties, while others ended up in disputes and litigation. The COVID-19 pandemic exposed the vulnerability and uncertainty of commercial lease agreements in times of crisis. It also highlighted the need for landlords and tenants to review and revise their contracts to include more clear and comprehensive terms that address potential scenarios like a pandemic. For example, some possible terms that could be added or modified are a force majeure clause that specifies what events qualify as force majeure, how they affect the parties' obligations, and what remedies are available in case of such events. A rent suspension or abatement clause that allows the tenant to stop paying rent or pay a reduced rent if the premises become unusable or inaccessible due to an event beyond the tenant's control. A rent adjustment clause that allows the parties to adjust the rent based on certain factors or indicators, such as market conditions, consumer demand, occupancy rate, etc. A termination clause that allows either party to terminate the lease agreement without penalty if certain conditions are met, such as prolonged closure of the premises, substantial loss of revenue, bankruptcy, etc. These are just some examples of possible terms that could be added or modified in commercial lease agreements to make them more resilient and adaptable in times of crisis. Of course, every lease agreement is different and depends on the specific circumstances and interests of the parties involved. Therefore, landlords and tenants should consult with their lawyers and negotiate in good faith to reach a fair and mutually beneficial agreement that reflects their current and future needs. Rent loss insurance and business interruption insurance are two types of coverage that can help landlords and tenants in different scenarios where a tenant's business is disrupted and unable to pay rent. Rent loss insurance reimburses a landlord for lost income while the property is being repaired or rebuilt under a loss covered by property insurance. For example, if a fire damages the building and the tenant has to move out temporarily, rent loss insurance can cover the rent that the landlord would have received from the tenant. Rent loss insurance is usually part of a landlord's property insurance policy or a business owner's policy. Business interruption insurance helps to replace lost business income if a tenant is unable to operate their business on a temporary basis due to a problem covered by the policy, such as theft, wind, fire, lightning, or falling objects. For example, if a storm knocks out the power and the tenant cannot run their business for a week, business interruption insurance can cover the lost revenue and operating expenses. Business interruption insurance is typically included as part of a tenant's commercial property insurance policy, or a business owner's policy. Both types of insurance have limitations and exclusions. Rent loss insurance does not cover losses that require other specific coverage, such as floods or earthquakes. It also does not cover losses due to COVID-19 or other communicable diseases. Business interruption insurance does not cover damage to property, which would be covered by commercial property insurance. It also does not cover losses due to floods or earthquakes, unless they are part of the existing policy. Rent loss insurance and business interruption insurance can provide financial protection for landlords and tenants in case of unexpected events that disrupt their normal operations and income. However, they are not interchangeable, and they do not cover every possible scenario. Therefore, it is important for both parties to understand their policies and their responsibilities before signing a lease agreement. Rent interruption due to the pandemic or other factors could lead to a wave of defaults among top property owners. If tenants stop paying rent or vacate the premises without notice, landlords may face financial and legal challenges. In this section, we will discuss how landlords should take careful steps to recapture rental property and deal with abandoned personal property. First, landlords should make sure that the tenant has actually moved out and relinquished legal possession of the rental unit. This can depend on local laws and the terms of the lease agreement. Landlords should check if the tenant has stopped paying rent, shut off utilities, returned the keys, or removed some of their belongings. Landlords should also try to contact the tenant to confirm their intention to leave. If possible, landlords should conduct a final walkthrough with the tenant and document the condition of the property. Second, landlords should determine whether the property left behind by the tenant has been abandoned. Abandoned property is still the tenant's personal property, but it has been left at the landlord's property without permission. Landlords should not dispose of or store abandoned property without following relevant laws in their area. Some states have specific rules on how long landlords must keep abandoned property before disposal and what kind of notice they must give to the tenant or third parties. Landlords should also check if the property has any value or lien attached to it. Third, landlords should follow proper procedures to recapture rental property and dispose of abandoned property. Landlords should avoid self-help measures such as changing locks, removing doors, or throwing away belongings without a court order. These actions could expose landlords to liability for trespass, conversion, or breach of contract. Landlords should seek legal advice or assistance from law enforcement if they encounter resistance from tenants or third parties. Landlords should also keep records of their actions and expenses related to recapturing rental property and dealing with abandoned property. By taking these careful steps, landlords can protect their rights and interests as property owners and avoid potential disputes and lawsuits with tenants or third parties. Rent interruption and default are serious issues that require proactive and prudent management from landlords.